Okay, this is take two. This is where the redo starts. Hi, this is Debbie Kuether here for Deliberate Indifference, Wisconsin. And today I've got something special for you in case you have heard any references made to the Calvin Fermin lawsuit. I'm going to be reading that today. I'm just going to be reading the complaint as is. And it was attempted to be served on me in December 23rd or 17th or something like that of 2023. And so we're going to take a look at that lawsuit. It was You'll see the parties named in there, but I do want to just give a quick background in terms of who is Calvin Fermin. So, Calvin Fermin was a city attorney for Milwaukee who represented Milwaukee Public Schools business while he was in the city attorney's office. After that, he moved over to Milwaukee Public Schools, where he became the deputy superintendent. Then he moved from being the deputy superintendent to being um, an attorney at Bulow Vetter in Milwaukee, or Wisconsin, and then he moved to being an administrative law judge in the Wisconsin Equal Rights Division. So he is now hearing cases in the Equal Rights Department, including employment cases. And during his time as a judge, he filed this suit against me, Cross Law Firm, and Ben Hitchcock Cross. So that's what we're going to do today. I'm going to read it just as it is, and we're going to make our way through this complaint. So let's switch here now. Here's the complaint itself, and we're going to go through it. If we can get that to work for us. There we go. So you can see he's got an intentional tort. You can see there's Calvin Fermin, um, Ben Hitchcock Cross, me, and Cross Law Firm are all defendants. And so I'm not going to necessarily read this introductory part. It's an amended summons. They're letting us know this is a lawsuit and we have 45 days to respond. You can see it was dated this June 2024. And I believe Calvin started working at the Equal Rights Division in April of 2024, I think, or maybe April of 2023. Anyways, that's not important at this moment. So he's got his name there. He's representing himself as an attorney. So he's representing himself. He's demanding a jury trial. Let's go ahead and get into this. Again, I won't read through the parties because I just mentioned the parties, the jurisdiction and venue, and we'll get right into the factual background. Buckle in because this is 48 pages. I'll try to go in an efficient way. Plaintiff Fermin has been a licensed attorney in good standing for over 11 years and is licensed in both the states of Wisconsin and Illinois. Plaintiff Fermin currently serves an administrative law judge for the Equal Rights Division of the Wisconsin Department of Workforce Development. As an ALJ for the ERD, Plaintiff Fermin hears claims of discrimination under the Wisconsin Fair Employment Act, the Wisconsin Family and Medical Leave Act, the Wisconsin Open Housing Law, the Wisconsin Public Places of Accommodation or Amusement Law, the Wisconsin Whistleblower Protection Act, I didn't realize that before, the Wisconsin Public Employee Safety and Health Law, the Wisconsin Internet Privacy Protection Act, the Wisconsin Bone Marrow and Organ Donation Leave Act, and other laws. As an ALJ for the ERD, Plaintiff Fermin also serves as mediator for some cases filed with the ERD under said laws. Plaintiff Fermin has previously served as Deputy Superintendent for Milwaukee Public Schools, as primary counsel for MPS and its Board of School Directors, as a municipal prosecutor, and as a plaintiff side civil practice solo practitioner. As Deputy Superintendent for MPS, Plaintiff Fermin initially oversaw the Office of Human Resources and the Office of Finance, to include MPS's risk management functions, with other Deputy Superintendent overseeing the Office of Academics and the Office of School Administration. Upon the retirement of the other Deputy Superintendent, Plaintiff took over the oversight of those other offices. As Deputy Superintendent, Plaintiff Fermin also served as liaison to the city attorney's office. Hmm. The MPS Office of Accountability and Efficiency and the MPS Audit Services Department on behalf of the MPS Office of the Superintendent. As primary counsel for MPS, Plaintiff Fermin advised all departments of MPS, its superintendent, and its board of directors on all legal aspects of the school district, to include advising on state and federal pupil instruction laws, labor and employment law, contract law, municipal law, and other areas of law. In this role, Plaintiff Fermin drafted, reviewed, and revised numerous contracts, reviewed and revised policies, procedures, and employee handbook provisions, and other transactional matters. Plaintiff Fermin also supported litigation on behalf of MPS, to include engaging directly in litigation on a limited basis and engaged in some alternative dispute resolutions on behalf of MPS. As a municipal prosecutor of the city of Milwaukee, Plaintiff Fermin held pretrial conferences with numerous defendants to fairly and accurately determine whether to prosecute the matter, and Plaintiff Fermin conducted trials to enforce the city's ordinances. In this role, Plaintiff Fermin also advised the City of Milwaukee's Department of Public Works on parking and towing statutory requirements and limitations, and Plaintiff Fermin drafted legal opinions and reviewed proposed ordinance on these issues. As a solo practitioner, Plaintiff Fermin represented plaintiffs in civil litigation and clients in civil transactional matters in various areas of law, to include consumer fraud, landlord tenant foreclosure, residential and commercial real estate, bankruptcy, immigration, traffic, and other areas. In addition to having obtained a Juris Doctor, Plaintiff Fermin earned a Master's of Business Administration from the University of Madison, Wisconsin. Plaintiff Fermin is certified as a mediator by the Center for Conflict Resolution and certified as a senior professional in human resources by the Human Resource Certification Institute. Plaintiff Fermin is a veteran of the United States Marine Corps, having served honorably for 5 years, including serving in Operation Iraqi Freedom. Defendant Hitchcock Cross is okay. So that was 16. We're up 16 and on page 4. Now we're getting into our paragraphs. Defendant Hitchcock Cross is an active attorney in good standing in the state of Wisconsin. The defendant Hitchcock Cross primarily offers legal services in the area of labor and employment. Defendant Hitchcock Cross is a practicing attorney with Defendant Cross Law Firm, primarily working out of Cross Law Firm's Milwaukee office. Upon information and belief, Defendant Hitchcock Cross has an ownership interest in Defendant Cross Law Firm as partner, shareholder, or similar title of an attorney with equity in the firm. Upon information and belief, Defendant Hitchcock Cross serves as a manager for Defendant Cross Law Firm. Defendant Kuether holds a PhD and is a client of Defendant Hitchcock Cross relative to an employment discrimination matter against MPS and its superintendent of schools, Dr. Keith Posley, concerning her employment at MPS. I guess he only named one defendant there. Upon information and belief, Defendant Kuether provides paralegal style assistance to Defendant Hitchcock Cross with some of his legal matters at Defendant Cross Law Firm. Defendant Hitchcock Cross and Kuether have created a YouTube channel titled Deliberate Indifference Wisconsin, herein the defendants' YouTube channel, where they post videos that they claim exemplify deliberate indifference, which they define as when someone recklessly disregards the risk of harm to another or the consequences of their actions. However, defendants Hitchcock Cross and Kuether routinely post videos that portray individuals as intentional bad actors. Defendants Hitchcock Cross and Kuether operate the defendants' YouTube channel as private individuals and not as part of a Wisconsin business entity, except that defendant Hitchcock Cross also operates or contributes to the defendant's YouTube channel in his official capacity as owner, manager, attorney, employee, and agent of Defendant Cross Law Firm. Upon information and belief, Defendant Cross Law Firm uses the defendant's YouTube channel as a mean to recruit clients to Defendant Cross Law Firm. Defendant Hitchcock Cross appears on screen and narrates the majority of the videos on the defendant's YouTube channel. Many of the videos on the defendant's YouTube channel consist of Defendant Hitchcock Cross actively participating as an attorney with Defendant Cross Law Firm through his taking of depositions or his direct or cross-examination of witnesses at hearings and his representation of clients of Defendant Cross Law Firm. Upon information and belief, most videos on the defendant's YouTube channel are recorded and edited at Cross Law Firm's Milwaukee office. Defendant Hitchcock Cross is primarily responsible for the editing and posting of the defendant's YouTube channel, and defendant Hitchcock Cross will monitor and respond to comments by the general public to those videos. Upon information and belief, deposition videos, hearing videos, and documents used in videos on the defendant's YouTube channel were obtained by defendant Hitchcock Cross in his official capacity as owner, manager, attorney, employee, and agent for defendant Cross Law Firm in the firm's representation of its clients. Whew, okay, we're still going. We're only on page 9. Upon information and belief, defendant Cross Law Firm's resources are used to record and publish videos for the defendant's YouTube channel or to otherwise support the defendant's YouTube channel. Defendant Kuether appears on screen and narrates some of the videos for the defendant's YouTube channel. Defendant Kuether also provides topics for some videos, researchers, and gathers information for some videos, assists with the review and editing of some videos, and monitors and responds to comments by the general public to videos on the defendant's YouTube channel. Defendant Kuether routinely republishes videos from the defendant's YouTube channel to other social media sites, including X and LinkedIn, a business and employment-focused social media platform primarily used for professional networking and career development, and for job seekers to post their resumes and for employers to post jobs. Defendants Hitchcock Cross and Kuether operate the defendant's YouTube channel, namely planning, recording, editing, and posting of the videos primarily within Milwaukee County. Though to the defendant's YouTube channel, defendants Hitchcock Cross and Kuether are primarily targeting an audience in the state of Wisconsin and more specifically in the Milwaukee area. Defendant Hitchcock Cross and defendant Kuether often make references in their videos that are more commonly understood by the general public in the Milwaukee area. Due to the local target audience, the defendant's YouTube channel has an despite the local target audience, the defendant's YouTube channel has an international audience. The defendant's YouTube channel has over 5,000 followers, or more than 5,000 different individuals who support the content of the channel and subscribe to the channel. Okay, so here's claim 1, defamation. Plaintiff Fermin realleges, incorporates by reference each and every one of the foregoing paragraphs. Plaintiff Fermin is a private individual and is neither a public official nor a public figure. Defendant Hitchcock Cross is a private individual and is not a news person or otherwise a member of the media. Defendant Hitchcock Cross is also an owner, manager, attorney, employee, and agent of the defendant Cross Law Firm. Defendant Kuether is a private individual and is not a news person or otherwise a member of the media. Defendant Cross Law Firm is not a news person, news organization, or otherwise a member of the media. Defendants Hitchcock Cross, Kuether, and Cross Law Firm have published unprivileged, false, and defamatory statements against Plaintiff Fermin in a series of videos on the defendant's YouTube channel and republished elsewhere, with all publications targeted at and available to the general public. These defamatory statements tend to harm Plaintiff Fermin's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. And these defamatory statements affect Plaintiff Fermin in his business, trade, profession, or office. Defendants Hitchcock Cross, Kuether, and Cross Law Firm have engaged in these repeated acts of defamation out of ill will, envy, spite, revenge, or other bad motives against Plaintiff Fermin. Defamation 1, false statements that Plaintiff Fermin engaged in a conspiracy, a coup, and a plot to oust the MPS Superintendent of Schools. On December 30th, 2022, defendant Hitchcock Cross published one defendant's YouTube channel on the YouTube channel video titled Deputy Superintendent and Board Investigators Failed Conspiracy to Oust MPS Superintendent Posley. Herein, defamation video number 1. This is a false statement because there was no conspiracy to oust the superintendent, and defendant Hitchcock Cross intentionally made this false statement. Defendant Hitchcock Cross's written description attached to the defamation video 1 states, Ben Hitchcock Cross breaks the story of how Deputy Superintendent Calvin Fermin in the Office of Accountability and Efficiency Matt Chasen conspired to oust the Milwaukee Public Schools superintendent Keith Posley. Again, this is a false statement because there was no conspiracy to oust the superintendent, and defendant Hitchcock Cross intentionally made this false statement. Defendant Hitchcock Cross's written description on the thumbnail of defamation video number 1 states conspiracy to oust souped, with the title of the video below the thumbnail. This thumbnail description and video title is visible when defamation video 1 appears in any playlist or list to include in a Google search result before anyone clicks to view the video. Conspiracy is commonly defined as an agreement between two or more persons to commit an unlawful act or to accomplish a lawful end by an unlawful means. In defamation video 1, defendant Hitchcock Cross stated, "Hello again, this is Ben Hitchcock Cross talking to you today for Deliberate Indifference Wisconsin about Calvin Fermin and Matt Chasen's plot to remove Keith Posley from the superintendent of Milwaukee Public Schools." This is a false statement because there was no plot to remove the superintendent, and defendant Hitchcock Cross intentionally made this false statement. Plot is commonly defined as a secret plan for accomplishing an usually evil or unlawful end. In defamation video 1, defendant Hitchcock Cross stated, "I think the coup fizzled out pretty quickly due to the fact that the board apparently is unwilling to take an action that even it knows that it should have done." This is a false statement because there was no coup against the superintendent, and defendant Hitchcock Cross intentionally made this false statement. Coup, also known as coup d'état, is commonly defined as a sudden, decisive exercise of force in politics, and especially the violent overthrow or altercation of an existing government by a small group. What defendant Hitchcock Cross falsely states was a conspiracy, a coup, and a plot to oust the superintendent was plaintiff Fermin's filing of a whistleblower complaint against the superintendent of schools with MPS's Office of Accountability and Efficiency, OAE, in accordance with MPS policies. The whistleblower complaint did not seek any specific disciplinary action against the MPS superintendent, but was filed to make the Milwaukee Board of School Directors, the MPS school board, as the supervisor to the superintendent, aware of potential wrongdoing. The OAE is an office within MPS designated to accept and investigate whistleblower complaints. Matt Chasen, Senior Director of OAE, is designated to accept and investigate whistleblower complaints for OAE. Plaintiff Fermin was required by MPS policy to file the whistleblower complaint at issue. The filing of a whistleblower complaint is not an unlawful or evil act. Plaintiff Fermin's filing of a whistleblower complaint with Matt Chasen in his official capacity is neither a conspiracy nor a coup nor a plot, but rather two employees undertaking their fiduciary duties to protect workers and avoid wrongdoing. Defendant Hitchcock Cross knew these statements to be false because his client, Deb Kuether, has similarly filed lawful whistleblower complaints with Matt Chasen and OEA, and she has made defendant Hitchcock Cross aware of this fact and of the whistleblower process at MPS. Additionally, defendant Hitchcock Cross represents or has represented other employees of MPS who have also filed lawful whistleblower complaints with Matt Chasen and OAE. Additionally, defendant Hitchcock Cross had plaintiff Fermin's whistleblower complaints, both a complaint at issue and another whistleblower complaint against an MPS chief, in his possession, and plaintiff Fermin outlined his obligation to file the whistleblower complaint along with the applicable MPS policies in those complaints. In defamation video 1, hold on, we're still on defamation video 1. Defendant Hitchcock Cross also falsely implied that plaintiff Fermin lied regarding not serving as an attorney for MPS or not giving legal advice to MPS while serving as deputy superintendent. In defamation video number 1, defendant Hitchcock Cross stated, "Now Calvin Fermin has said repeatedly under oath that he did not give any legal advice to anybody at MPS, even though he was an attorney while he was the deputy superintendent. So he's still an attorney. He's from the city attorney's office, but he's not representing MPS or Keith Posley because he is a deputy superintendent. not an attorney for MPS. Those facts and of themselves, I think, are key to understand on what is going on here with those statements themselves. Then defendant Hitchcock Cross later said Calvin Fermin discusses the law with Mr. Chasen and advises him that Posley can be excluded from board meetings if the object of the board meeting is discipline against Mr. Posley. There was a citation in Mr. Chasen's notebook of the law on that, and I don't suppose that he got that from himself. I believe that came from Fermin. Underline added for emphasis. Oh, these are the underlines. Defendant Hitchcock Cross uses these false statements to clearly imply that plaintiff Fermin was lying about not giving legal advice to MPS while serving as a deputy superintendent, and to also imply that plaintiff Fermin engaged in the unauthorized practice of law. These statements are clearly false because it is not the practice of law to discuss or identify Wisconsin statutes. I thought we just read about that. The practice of law in Wisconsin is the application of legal principles and judgment with regard to the circumstances or objectives of another entity or persons, where there is a client relationship of trust or reliance, and which require the knowledge, judgment, and skill of a person trained as a lawyer. SCR 23.01. The mere discussion or identification of Wisconsin statute cannot be deemed the practice of law. Wait a second. Who else does that? And defendant Hitchcock Cross, who is an active attorney in Wisconsin, knew or should have known this to be true. Additionally, an active license to practice law in Wisconsin is not needed for governmental agencies and their employees carrying out responsibilities provided by law. Supreme Court Rules 23.02, Parent 2, Sub N, Plaintiff Fermin and Mr. Chasen were engaged in the whistleblower process to avoid potential discrimination or other wrongdoing as required by the Wisconsin Fair Employment Act, Title VII, and Wisconsin Statute 118, and other laws. Thus, engaging in this whistleblower process is not the practice of law, and defendant Hitchcock Cross, who is an active attorney practicing in labor and employment law in Wisconsin, knew or should have known this to be true. Defendant Hitchcock Cross's false statements are defamatory because they tend to harm plaintiff Fermin's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. Defendant Hitchcock Cross's false statements are defamatory statements that affect plaintiff Fermin in his business, trade, profession, or office, especially in the light of the implication of dishonesty and untrustworthiness through defendant Hitchcock Cross's false statements that plaintiff Fermin lied and engaged in a conspiracy plot or coup to oust his supervisor. Knowing the conspiracy statement to be false and defamatory against plaintiff Fermin, defendant Hitchcock Cross calls defamation video number 1 to be republished without any reference to a conspiracy in what will now be defamation video number 2. However, in doing so, defendant Hitchcock Cross did not remove or retract defamation video number 1, allowing it to continue to defame plaintiff Fermin. Defendant Hitchcock Cross has made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against plaintiff Fermin. Namely, defendant Hitchcock Cross has made these defamatory statements against plaintiff Fermin because plaintiff Fermin was a senior executive at MPS while defendant Kuether's alleged discrimination occurred. Additionally, defendant Hitchcock Cross acted out of ill will and revenge because plaintiff Fermin opposed a third-party subpoena for documents that defendant Hitchcock Cross served on him in defendant Kuether's employment discrimination matter. Additionally, defendant Hitchcock Cross acted out of ill will and revenge because, as defendant Hitchcock Cross has said in what will be defamation video number 3, he believes that he and defendant Kuether worked very hard to get plaintiff Fermin's deposition in defendant Kuether's employment discrimination matter, and that plaintiff Fermin, at least impliedly, somehow was the reason for this difficulty. Defendant Hitchcock Cross acted both in his personal capacity and his official capacity as owner, manager, attorney, employee, and agent of defendant Cross Law Firm in making and publishing these defamatory statements. Upon information and belief, defendant Hitchcock Cross obtained the documents that were used in Defamation Video 1 through discovery, record requests, should have wrote public records requests, or from clients, all in his official capacity as owner, manager, attorney, employee, and agent of defendant Cross Law Firm. Upon information and belief, Defamation Video number 1 was recorded, edited, and posted to the defendant's YouTube channel from Cross Law Firm's Milwaukee office. Upon information and belief, defendant Cross Law Firm's resources were used to record and publish Defamation Video number 1 to the defendant's YouTube channel. Defendant Kuether caused the false and defamatory statements to be published by her participation in the preparation, editing, and posting of Defamation Video number 1, as well as her continued publishing of responses to comments in Defamation Video number 1 without correcting or retracting the false and defamatory statements. Defendant Kuether caused the false and defamatory statements to be published by her republishing of Defamation Video number 1 to LinkedIn, separate social media website targeted at and open to the general public. See attachment number 3. Defendant Kuether caused the false and defamatory statements to be published by republishing of Defamation Video 1 to X, formerly known as Twitter, a separate social media website targeted at and open to the general public. See exhibit number 4 attached. Upon information and belief, defendant Hitchcock Cross coordinated with defendant Kuether for her to post the false and defamatory statements through other social media sites as part of their joint venture that is the defendant's YouTube channel. Defendant Kuether knew these statements to be false because she has similarly filed lawful whistleblower complaints with Matt Chasen and OAE. Additionally, defendant Kuether had plaintiff Fermin's whistleblower complaints in her possession, and plaintiff Fermin outlined in those whistleblower complaints his obligation to file the whistleblower complaint along with other applicable MPS policies. Oh my goodness, we're only on 18 of 48. This is going to take forever. Defendant Kuether's false statements are defamatory because they tend to harm plaintiff Fermin's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. Defendant Kuether's false statements are defamatory statements that affect plaintiff Fermin in his business, trade, profession, or office, especially in light of her republishing the false and defamatory statements to the business employment-focused social media site LinkedIn. Golly. Defendant Kuether has made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against plaintiff Fermin. Namely, defendant Kuether has made these defamatory statements against plaintiff Fermin because plaintiff was a senior executive at MPS while her alleged discrimination occurred. Additionally, defendant Kuether acted out of ill will and revenge because plaintiff Fermin opposed a third-party subpoena for documents that defendant Kuether had served on him in her employment discrimination matter. Additionally, defendant Kuether acted out of ill will and revenge because she believes that she and defendant Hitchcock Cross worked very hard to get plaintiff Fermin's deposition in her employment discrimination matter, and that plaintiff Fermin, at least impliedly, somehow was the reason for this difficulty. At the Defamation Video number 1 was published and republished by defendants Hitchcock Cross and Kuether. Plaintiff Fermin was an attorney in a private practice at a law firm. At the time plaintiff Fermin viewed Defamation Video number 1 on November 9th, 2023, Defamation Video number 1 had 887 views and 20 likes, or 20 different individuals expressing support for the content of the video. Defamation Video number 1 remained posted as the time of the commencement of this action, which caused plaintiff Fermin to continue to be defamed by Defamation Video number 1. Defamation number 2. False statements that plaintiff Fermin engaged in a coup and a plot to oust the superintendent of schools, MPS superintendent of schools, were on number 83, folks. On October 31st, 2023, defendant Hitchcock Cross published on the defendant's YouTube channel a video titled Matt Chasen and Calvin Fermin correspond to oust K. Posley as Milwaukee Public Schools Superintendent. Herein, defamation video number 2. See exhibit number 5 attached. This is a false statement because Plaintiff Fermin and Mr. Chasen did not correspond to oust the superintendent, and Defendant Hitchcock Cross intentionally made this false statement. Plaintiff Fermin and Mr. Chasen were addressing alleged misconduct through the whistleblower process. Defamation Video 2 is a republish of Defamation Video number 1, with the exception that there is no reference to conspiracy in Defamation Video number 2. However, the false and defamatory statements regarding a coup and a plot to oust the MPS superintendent remain in Defamation Video number 2. In Defamation Video number 2, Defendant Hitchcock Cross stated, "Hello again, this is Ben Hitchcock Cross talking to you today for Deliberate Indifference, Wisconsin, about Calvin Fermin and Matt Chasen's plot to remove Keith Posley from superintendent of Milwaukee Public Schools." This is a false statement because there was no plot to remove the superintendent, and Defendant Hitchcock Cross intentionally made this false statement. Plot is commonly defined as a secret plan for accomplishing an usually evil or unlawful end. In Defamation Video 2, Defendant Hitchcock Cross also stated, "I think the coup fizzled out pretty quickly due to the fact that the board apparently is unwilling to take the action that even it knows it should have done." This is a false statement because there was no coup against the superintendent, and Defendant Hitchcock Cross intentionally made this statement. Coup, also known as a sudden decisive exercise. Oh, I skipped a line. Of force in politics, and especially the violent overthrow or altercation of an existing government by a small group. What Defendant Hitchcock Cross falsely states was a coup and a plot was Plaintiff Fermin's filing of a whistleblower complaint against the superintendent's schools with MPS's Office of Accountability and Efficiency in accordance with MPS policies. The OAE is an office with MPS designated to accept and investigate whistleblower complaints. Matt Chasen, Senior Director of OAE, is designated to accept and investigate whistleblower complaints for OAE. Plaintiff Fermin was required by MPS policy to file the whistleblower complaint at issue. The filing of a whistleblower complaint is not an unlawful or evil act. Plaintiff Fermin's filing of a whistleblower complaint with Matt Chasen in his official capacity is neither a coup nor a plot, but rather two employees undertaking their fiduciary duties to protect workers and avoid wrongdoing. Defendant Hitchcock Cross knew these statements to be false. His client, Defendant Kuether, has similarly filed lawful whistleblower complaints with Matt Chasen and OAE, and she's made Defendant Hitchcock Cross aware of the fact that whistleblower process is at MPS. Additionally, Defendant Hitchcock Cross represents or has represented other MPS employees who have also filed whistleblower complaints with Matt Chasen and OAE. Additionally, Defendant Hitchcock Cross had Plaintiff Fermin's whistleblower complaints, both a complaint at issue and another whistleblower complaint against an MPS chief in his possession, and Plaintiff Fermin outlined his obligation to file the whistleblower complaint along with the applicable MPS policies in those complaints. In Defamation Video number 2, Defendant Hitchcock Cross also falsely implied that Plaintiff Fermin lied regarding not serving as an attorney for MPS or not giving legal advice to MPS while serving as deputy superintendent. In Defamation Video number 2, Defendant Hitchcock Cross stated, "Now Calvin Fermin has said repeatedly under oath that he did not give any legal advice to anybody at MPS, even though he was an attorney while he was deputy superintendent. So he's still an attorney. He's from the city attorney's office, but he's not representing MPS or Keith Posley because he is the deputy superintendent, not an attorney for MPS. Those facts in and of themselves, I think, are key to understand what is going on here with those statements themselves." Then Defendant Hitchcock Cross later said, Calvin Fermin discusses the law with Mr. Chasen and advises him that Polsey can be excluded from the board meetings if the object of the board meeting is discipline against Mr. Polsey. There was a citation in Mr. Chasen's notebook on the law on that, and I suppose he didn't get that from himself. I believe that came from Fermin. Defendant Hitchcock Cross uses these false statements to clearly imply that plaintiff Fermin was lying about not giving legal advice to MPS while serving as deputy superintendent, and to also imply that the plaintiff Fermin engaged in unauthorized practice of law. These statements are clearly false because it is not the practice of law to discuss or identify Wisconsin statutes. These statements are clearly false because it is not the practice of law to discuss or identify Wisconsin statutes. I read that twice for emphasis. The practice of law in Wisconsin is the application of legal principles and judgment with regard to the circumstances or objectives of another entity or persons where there is a client relationship of trust or reliance, and which require the knowledge, judgment, and skill of a person trained as a lawyer. That's at Supreme Court Rule 23, number 1. The mere discussion or identification, listen to this, the mere discussion or identification of a Wisconsin statute cannot be deemed the practice of law, and deemed Hitchcock Cross, who is an active attorney in Wisconsin, knew or should have known this to be true. Additionally, an active license to practice law in Wisconsin is not needed for government agencies and their employees carrying out responsibilities provided by law. Plaintiff Fermin and Mr. Chasen were engaged in the MPS whistleblower process to avoid potential discrimination or other wrongdoing as required by the Wisconsin Fair Employment Act, Title VII, and the Wisconsin Statute 118. Thus, engaging in this whistleblower process is not the practice of law, and defendant Hitchcock Cross, who is an active attorney practicing in labor and employment law in Wisconsin, knew or should have known this to be true. Defendant Hitchcock Cross's false statements are defamatory because they tend to harm plaintiff's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. We're at 101, people. I'm trying to go as fast as I can. Defendant Hitchcock Cross's false statements are defamatory statements that affect plaintiff Fermin in his business, trade, profession, or office, especially in light of the implication of dishonesty and untrustworthiness through defendant Hitchcock Cross's false statements that plaintiff Fermin lied and engaged in a plot or coup to oust his supervisor. Defendant Hitchcock Cross made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against Fermin. Namely, defendant Hitchcock Cross has made these defamatory statements against plaintiff Fermin because plaintiff Fermin was a senior executive at MPS while defendant Kuether's alleged discrimination occurred. Additionally, defendant Hitchcock Cross acted out of ill will and revenge because plaintiff Fermin opposed a third-party subpoena for documents that defendant Hitchcock Cross served on him in defendant Kuether's employment discrimination matter. Additionally, defendant Hitchcock Cross acted out of ill will and revenge because, as defendant Hitchcock Cross has said in what will be defamation video number 3, he believes that he and defendant Kuether worked very hard to get plaintiff Fermin's deposition, and that plaintiff Fermin, at least impliedly, somehow was the reason for this difficulty. Defendant Hitchcock Cross acted both in his personal capacity and in his official capacity as an owner, manager, attorney, employee, and agent of defendant Cross Law Firm in making and publishing these defamatory statements. Upon information and belief, defendant Hitchcock Cross obtained the documents that were used in defamation number 2 through discovery. He's got records requests or from clients in his official capacity as owner, manager, attorney, employer, and agent of the defendant Cross Law Firm. Upon information and belief, defamation video number 2 was recorded, edited, and posted to the defendant's YouTube channel from Cross Law Firm's Milwaukee office. Upon information and belief, defendant Cross's law firm resources were used to record and publish defamation video number 2 to the defendant's YouTube channel. Defendant Kuether caused the false and defamatory statements to be published by her participation in the preparation, editing, and posting of defamation video number 2, as well as her continued publishing of responses to comments to defamation video number 2 without correcting or retracting the false and defamatory statements. Defendant Kuether knew these statements to be false because she has similarly filed lawful whistleblower complaints with Matt Chasen and OAE. Additionally, defendant Kuether had plaintiff Fermin's whistleblower complaints in her possession, and plaintiff Fermin outlined his obligation to file the whistleblower complaint along with any applicable MPS policies. Defendant Kuether's false statements are defamatory because they tend to harm plaintiff Fermin's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. Defendant Kuether's false statements are defamatory statements that affect plaintiff Fermin in his business, trade, profession, or office, especially in light of the implication of dishonesty and untrustworthiness through the false statements that plaintiff Fermin lied and engaged in a plot coup to oust his supervisor. Defendant Kuether has made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against plaintiff Fermin. Namely, defendant Kuether has these defamatory statements against plaintiff Fermin because plaintiff Fermin was a senior executive at MPS while her alleged discrimination occurred. Additionally, defendant Kuether acted out of ill will and revenge because plaintiff Fermin opposed a third-party subpoena for documents that defendant Kuether had served on him in her employment discrimination matter. Additionally, defendant Kuether acted out of ill will and revenge because she believes that she and defendant Hitchcock Cross worked very hard to get plaintiff Fermin's deposition in her employment discrimination matter, and that plaintiff Fermin, at least impliedly, somehow was the reason for this difficulty. I don't even know what he's talking about there. At the time defamation video number 2 was published by the defendants Hitchcock Cross and Kuether, plaintiff Fermin was and still is an ALJ with the ERD. At the time, plaintiff Fermin's video defamation number 2 on November 9th, 2023, defamation video number 2 had 320 views, 39 likes, or 39 different individuals expressing support for the content of the video. Defamation video number 2 remained posted as a time commencement of this action, which caused plaintiff Fermin to continue to be defamed by defamation video number 2. I got ahead of myself because on page 23, number 115 starts defamation video number 3. False statements that plaintiff Fermin is a bad actor, a liar, and is unqualified and biased as an administrative law judge. On November 7th, 2023, defendant Hitchcock Cross published on the defendant's YouTube channel another false and defamatory video, herein defamation video number 3. Defendant Hitchcock Cross confirms in defamation video number 3 that the content of the video is all about plaintiff Fermin when he stated, "I have a few things to talk about here." And it really boils down to Calvin Fermin is now an administrative law judge at the Equal Rights Division. Though through defamation video number 3, defendant Hitchcock Cross defames plaintiff Fermin through a combination of false statements, mixed opinions, implication, and innuendo to falsely state that plaintiff Fermin is unqualified to be an ALJ, that plaintiff Fermin is or will be biased as an ALJ, that plaintiff Fermin is a bad actor relative to discrimination and corruption, and that plaintiff Fermin is a liar. These series of false statements tend to harm plaintiff Fermin's reputation as to lower him in the estimation of the community or deter third persons from associating or dealing with him. And they affect plaintiff Fermin in his business, trade, profession, or office as an ALJ. Defendant Hitchcock Cross titled defamation video number 3, Equal Right Division hires new judge. School board attorney and alleged bad actor. See exhibit number 6 attached. This is a false statement because plaintiff Fermin is not an alleged bad actor, and defendant Hitchcock Cross intentionally made this false statement. Defendant Hitchcock Cross falsely states that plaintiff Fermin is an alleged bad actor because defendant Hitchcock Cross asserts that his client, defendant Kuether, alleges that plaintiff Fermin is a bad actor in an employment discrimination complaint she filed against MPS. But defendant Hitchcock Cross knows this to be false. The alleged bad actor in defendant Kuether discrimination complaint is Superintendent Keith Posley. Defendant Kuether has not alleged plaintiff Fermin to be a bad actor. Defendant Kuether acknowledged that Superintendent Posley is the alleged bad actor in his case and not plaintiff Fermin. In her written comment attached to defamation video number 3, which states Calvin Fermin filed a whistle complaint after I filed mine. For my complaint, I was locked in a room and stripped of my 27-year career. I had nothing but exemplary evaluations the entire 27-year period, and there is no evidence of me ever being unprofessional. I filed a complaint and the superintendent retaliated. As for Fermin, he went on to a private law firm, Bulow Vetter, which is one of the 2 firms MPS pays to oppose my case, and now he is rewarded with a judgeship in the Equal Rights Division. For similarly situated people, he underlined that because he just had to emphasize that. How dare I say that? He got accolades and promotions, and I got physically insulted and have no ability to have employment. For the same behavior, males get rewarded and females get discarded. It is painful. Underline added for emphasis. See exhibit number 7 attached. Defendant Hitchcock Cross also acknowledges in defamation video number 3 that Superintendent Posley is the alleged bad actor in defendant's discrimination case when he said, "What happened is Keith Posley, the superintendent and bad actor in Debbie Kuether's case, said somebody who I personally believe is totally unfit to do their job." And again, Posleyism is what we say. That's his style of operation, which is violence in the defense of ignorance. Underline added for emphasis. Thus, defendant Hitchcock Cross confirms that Superintendent Posley is the alleged bad actor in defendant Kuether's case and not plaintiff Fermin. But defendant Hitchcock Cross nonetheless intentionally made the false statement that plaintiff Fermin is an alleged bad actor solely to defame plaintiff Fermin. Defendant Hitchcock Cross repeats the false statement that plaintiff Fermin is an alleged bad actor in defamation video number 3 when he said Calvin Fermin is alleged to be a bad actor in the Debbie Kuether case because Debbie Kuether met with him and she was immediately retaliated against. This is blatantly false since both defendant Hitchcock Cross and defendant Kuether know that they allege Superintendent Posley to have retaliated against her and that he is the alleged bad actor and not plaintiff Fermin. Shockingly, defendant Hitchcock Cross later in defamation video number 3 drops the word alleged from the false statement, plainly calls plaintiff Fermin a bad actor. In discussing plaintiff Fermin's hire as an ALJ by the ERD, defendant Hitchcock Cross said, "And whoever is making the decision knew or should have known that this person was a bad actor." In addition to calling plaintiff Fermin a bad actor, defendant Hitchcock Cross's statement further implies that plaintiff Fermin was found to be a bad actor or found to have committed discrimination against defendant Kuether by the ERD, which intentionally relies on a false statement. Defendant Kuether, through her attorney, defendant Hitchcock Cross, withdrew her employment discrimination complaint against MPS from the ERD, so there was no finding of discrimination at a hearing in her case because there was no hearing. As on the commencement of this action, defendant Kuether, through her attorney, defendant Hitchcock Cross, has filed her employment discrimination complaint in federal court against MPS and 11 named defendants, Superintendent Posley, Dr. Holliday, and the 9 board members of MPS's Board of School Directors. Defendant Kuether, through her attorney, defendant Hitchcock Cross, did not name plaintiff Fermin as a defendant in her federal employment discrimination case prior to the commencement of this action. This is because plaintiff Fermin is neither a bad actor nor an alleged bad actor. In defamation video number 3, defendant Hitchcock Cross also implied that plaintiff Fermin is a bad actor when defendant Hitchcock Cross stated, "If you Google Calvin Fermin, which they must have done, he could be a character in deliberate indifference. There is no doubt about that." Defendant Hitchcock Cross's reference to Plaintiff Fermin being a character in Deliberate Indifference, the defendant's YouTube channel, implies that Plaintiff Fermin is a bad actor because of how defendants Hitchcock Cross and Kuether define deliberate indifference on the defendant's YouTube channel, but more specifically because of how they portray individuals as being intentional bad actors on the defendant's YouTube channel. Defendant Hitchcock Cross's written description attached. Oh, did I freeze here? Oh, I may have frozen. Um, Not sure we have